Quietly, on August 20th, 2025, a new directive slipped into the Social Security Administration's internal rulebook, the POMS entry SI 02220, transmittal number 135, issued by ORDP/OASP, and it carries very real consequences. The title is dry. Recovery Procedures for Supplemental Security Income, SSI, Overpayments. The meaning is not. When SSI pays too much and the person is no longer on SSI, the case can now be built, documented, and sent to the Department of Justice for a civil lawsuit. This isn't just another notice, it's a step-by-step pathway from desk to courtroom. And while SSI and SSDI are different programs, the collection posture mirrors across titles like DAC and retirement, so the logic here casts a long shadow. For years, the federal stance swung like a pendulum. In the pandemic era, overpayment collection was softened, paused, or forgiven around the edges, and many felt instant relief. But the debt didn't evaporate. It waited. With the national debt around $37 trillion, the tone hardened. Stewardship first, recovery prioritized. This update doesn't argue the politics, it operationalizes them. It tells technicians exactly when to escalate, what to prove, and how to ready a file so a U.S. attorney can walk into court and collect. The update to SI 02.220.035 reorganizes and tightens the screws. It adds explicit legal citations, moves scattered policy lines into a coherent subsection, and spells out refer versus don't refer with far less ambiguity. A notable shift: in death cases with no estate, the practical "don't bother" line moves from 3,000 to 5,000, tracking GN 02.215.150 because paying lawyers more than the debt is bad stewardship. The section also clarifies the statute of limitations, defines tolling, and modernizes procedure. CCLR packets go to DOJ by email, roles for field offices, FO, and regional offices, RO, are cleaned up, and language is brought up to QUICC standards. None of this is academic. It is a blueprint for action. When does a file move to DOJ? Only after SSA tries ordinary recovery and fails, benefit adjustment, refund request, or compromise. DOJ referral also applies if a representative payee misused funds or a former payee failed to transfer conserved funds. Then comes the checklist. First, SSA must show that all reasonable in-house recovery failed. Second, debt size, in general at least $3,000 unless special categories apply. Third, the statute of limitations must still be open. Fourth, DOJ must be able to prove the overpayment using the Claims Collection Litigation Report, CCLR, plus evidence. Fifth, the person must be locatable. Sixth, there must be income or assets that make recovery plausible. And seventh, the cost of litigation should not exceed expected recovery, except in specific cases like federal employees or fraud, where public stewardship demands action beyond a strict cost test. If fraud is in play, civil enforcement waits until OIG/DOJ resolves the fraud track. Civil is not a shortcut around criminal. It's what follows when the facts are settled. There are explicit "don't refer" flags too. A death case with no estate and low balance? Don't sue when there's nothing to recover, especially under the $5,000 practical threshold. Bankruptcy changes the air pressure. If a case is pending or debt has been discharged, civil enforcement is stayed or blocked. And if fraud questions aren't resolved, finish them before civil referral. This is a machine with brakes as well as a throttle. The numbers matter, and they're blunt. If you are a federal employee, referral can happen at just $200. That's not a typo. The reasoning is simple. Predictable employment records, steady pay, and high odds of recovery. If you are not a federal employee, the floor is generally $3,000 once normal recovery fails and there's no unresolved fraud. Then comes the ability to repay test. Under the income-only route, if monthly income exceeds ordinary and necessary expenses by more than $250, and that surplus would retire at least $3,000 within 60 months, the case qualifies for referral. Under the income plus resources route, a combination of income and liquidable assets that clears $3,000 within 60 months also qualifies. If complete financials aren't provided, DEQY/CQY records showing greater than $10,000 in annual earnings plus available pay stubs in the evidence portal can fill the gap, assuming the other criteria in SI 02-220.035B are met. And if it's a federal employee and ordinary probing goes nowhere, confirmation of federal employment, coupled with the rest of the checklist, can still justify referral. On cost, staff are told to verify that litigation costs won't exceed recovery, but the policy carves out exceptions. Federal employee debts greater than or equal to $200 in fraud can move forward even if the math is tight. The clock is critical. DOJ generally has 6 years from the date of delinquency to sue. Miss it, and civil litigation is barred. But there are 2 traps that extend the window. If the person makes a partial payment or acknowledges the debt in writing, the 6-year clock restarts, and time pauses while the person is outside the U.S. territories DCPR, is under 18, mentally incompetent, covered by diplomatic immunity, or while the United States is in a war formally declared by Congress. Operationally, SSA is told to refer within 1 year of the most recent delinquency, and in any event at least 1 year before the statute expires, to give DOJ room to file. Here's how the machine moves in practice. Before referral, the field office or regional office must document ability to pay, reports of contact, financials, earnings evidence, assess provability, following GN 02215.160 for what a U.S. attorney needs, and send a 30-day notice warning that DOJ referral will happen unless the full overpayment is refunded. They then prepare the Certificate of Indebtedness and the CCLR and send the packet to DOJ by email, archiving everything in SSA systems. Once referred, routine refund dunning stops. If no formal suit notice has gone out yet, SSA may accept any refund and notify the regional office, which updates the U.S. attorney. After a suit notice arrives, SSA will only accept full payment. Any partial must go through the U.S. attorney. If the person later regains SSI eligibility, SSA pivots to recover by check adjustment, benefit offset, and informs DOJ. And when DOJ recovers the full amount, or the person proves payment to DOJ, SSA terminates adjustments. Consequences stack in layers. Administrative actions come first. Offsets, withholding, program penalties. Civil action is next. Lawsuits, judgments, and long-tail collection tools. Criminal action follows fraud, charges, fines, incarceration, and supervision. Civil is quiet but relentless. A judgment can follow for years and reframe your finances in ways most people don't anticipate. There are practical exits and pressure valves. Negotiation is real. Many repayment plans begin around $100 to $200 per month. If your costs rise or income falls, you can ask for a reevaluation and push for a lower monthly amount, especially with living costs still elevated before any tariff effects wash through the supply chain. Bankruptcy places an automatic stay on collection while pending, and in some cases a discharge can wipe the balance. During the stay, civil referral pauses. Be careful with the clock. A casual partial payment or a well-intentioned letter can reset the 6-year window and give DOJ fresh time. And if you re-establish SSI, expect offsets rather than lawsuits, but don't mistake that for forgiveness. The debt remains until satisfied or waived. Step back and the message is unmistakable. The era of let it slide is over. The government has codified documentation, thresholds, timelines, and burden of proof so that when a case qualifies, it moves, cleanly, legally, and with teeth. Main Street feels it first. Some overpayments are ancient, some born from agency error or rules too complex to parse. But creditors measure outcomes, not confusion. Behind every SSA letter stands the U.S. Treasury and, if needed, the Department of Justice. They collect. That is their mandate. What comes next is the map behind the map. The exact cost of litigation breakpoints, the evidence DOJ prizes inside the CCLR, the subtle tolling scenarios that stretch the statute, and the places where SSI rules mirror SSDI and retirement, and where they quietly diverge. That knowledge is leverage. It can keep a file from crossing the line into federal court, or at least shape the terms if it does. If this helped you see the process clearly and on your terms, subscribe to stay ahead of the next moves, like to keep this analysis circulating to those who need it, and share your experience in the comments so others can learn what actually happens when the letters start. And here's the question to carry forward. If a single sentence in your paperwork can restart the government's 6-year clock against you, what other routine forms are silently working for or against you right now?